Pastor Kelly. Thank you all for coming. I appreciate you being here. My wife and I started attending here in 1999, so, at the other place, yeah. But I'm sure most of you know me from my big epic scene in The Chosen, but that's my wife and I right there. They got my best side, and it was epic. They used to call them extras. They're now called background actors. There's another shot of us. Yes? I ran out. I did like, here, I have like, I got 3 or 4 right here. That's the end. Somebody must have found out that I was the one speaking today. And so here we go. We got a crowd. Thank you so much for coming again. Tonight we're going to talk about how wills work, how trusts work, and how they're different. What's probate? How do we avoid the probate process? What triggers a probate here in Virginia? We'll talk about what happens if you don't have a plan. The I'll get to it someday plan. What if you die with just a last will versus a revocable living trust? What's the outcome to your family if you do this versus that? I always tell people, you need to make the right decision for your family, but you can't make decisions if you don't have choices and you don't understand what the choices are. So my goal tonight is to help you really understand this so you can do the right thing for your family. It says in Proverbs, a good person leaves an inheritance to their children and children's children. This is a biblical subject, although it's not real biblically, it's got the Bible. It's all about money. It's about resources. It's about being a good steward of the assets the Lord's given us. We know God has no problem with us having wealth, but he doesn't want wealth to have us, right? So we're going to talk about what can we do with the resources God's given us. And we'll talk about what's the best way to pass our assets to our family. And that's what we want to do, or to church, or to ministry. People over the years have asked me, what is estate planning? And I like to tell people what it's not. It's not financial planning. Most of you have already done that, investing and growing your wealth. And then there's retirement planning, which is sort of a different phase of financial planning. Like, I don't want to work forever. At some point, I want to stop and let my money work for me, right? That's the goal. But then there's a third planning, and it's estate planning. And it basically is making sure that all that we've accumulated in this world goes to the right people at the right time, without fighting, without the courts, without the probate mess. That's the goal of a good estate plan. So when they've asked me, can you give me a sentence, I came up with this. Estate planning is the process of putting together effective legal documents so that what you want actually takes place. We all have wishes and wants. I don't want my kids to fight. I don't want my son-in-law to get anything. But I will remind you, what you want and what you get is going to vary based on what you do. So we have the ability to orchestrate through good documents, and that's what we're going to talk about this evening. So let's dive into it. Some people's estate plan consists of this. Every year you say, well, didn't do it last year, I'm going to do it this year, until next year when you say it again. And it's just a series of kicking it down the road. It's important, but you never quite get to it. Well, folks, if you die without a plan, and I mean no will or no trust, that is called dying intestate. And folks, when you die without a plan, you do get a plan. It is called the government plan. And groans. And the state in which you died, in this case, the Commonwealth of Virginia, will create a will for your family after you're gone. Now, this new government written will has to go through a legal process called probate, where the assets will be tied up in the courts, and the family has the opportunity to get together and argue over the things you left. There are 2 things that I'm pretty sure you do not want. You do not want to send your family to court, and you do not want the government to write your will. Now, when the state writes the will for someone who died without a will, the state does not know any of the family details. The government doesn't know that Susie already got her inheritance, and Jimmy hasn't talked to Dad in 10 years, and Barbara never paid back those loans. But you know who does know the family details? The family. So when they get together in the courtroom, it sometimes sounds like this. Your Honor, this will you guys came up with? Not even close. She shouldn't get, he already got, Mom wanted me to have, and guess what they wind up doing in court is they wind up fighting. Now, do you know who wins that fight? Besides the state and some local attorney, who often wins that fight is just the person that hired the better attorney. Jimmy, the more clever son, hires a good lawyer, and when it all shakes out, he winds up with more. The worst part about letting the family work it out, in some cases it's worse than that, the worst part is very often the end result is they don't talk to each other. And sometimes that lasts for decades because of what she got away with or what he tried to get away with. I will admit this, the do-nothing plan is the least expensive plan available for you today, but it is certainly not the plan you want. It is the plan that will cost your family the most time, money, and aggravation. So again, don't go out without a plan. Make at least that decision in your life. I'm not leaving this earth without doing something, okay? Putting something in place. Well, that being said, that I can do something, let's go over a couple more options. You could do something called a last will and testament. Now, everybody in here has heard of a will, and some of you probably already have a will. And let me remind you what a will is. A will is basically a set of instructions that says, something to the effect, when I die, I want these things to go to these people, right? It's a distribution document. But what you may not know is your will, when you die, it has to go through probate. Whether you write the will or the state writes the will because you didn't, wills have to go before a probate court and a probate judge. Now, I'm going to use the word probate a few times this evening, and I thought you might want to know where the word came from. And if you don't, I'm still going to tell you. Probate comes from a Latin word. The Latin word, the root word is probare. The word probare meant to test or to prove or to challenge something. What is being tested or challenged very often in the probate court is the will. Somebody doesn't like what mom wrote, and so they come in and they come up with some reason why you're not supposed to follow these instructions. That's called contesting the will or challenging it. Now, usually people aren't so brazen to say, I'm not getting enough, Your Honor. They have some reason why you shouldn't, follow this. So some of the reasons are like, Your Honor, that doesn't even look like Dad's writing. I know that's not what he wanted. So the accusation, it was someone else drew it up after he died, We were looking forever, and then this one showed up. It might be another one where somebody goes, oh gosh, Mom was saying all kinds of crazy stuff at the end. I don't think she was mentally competent to draw up this document, so the accusation she wasn't of sound mind. I can bring witness to some of the stories, Another one might be, Your Honor, all of my life I was told I was getting this property. I saw a will that says I'm getting this property, but this new document appears giving everything to her. I think she talked Mom into, and then you hear the word undue influence, the caretaker, and suddenly things change. Bottom line is, if someone doesn't like the will, when you die, they can contest it. Wills are not binding. Wills are a set of instructions, but they're not binding. The court can, after listening to everybody, change what you've written. A will, by the way, does not help us at all if we become incapacitated prior to death. I'm talking, Alzheimer's, dementia, massive stroke, a car accident. Because, folks, a will does not go into effect until you are dead. So a will is an option, but it's a very narrow option. It only deals with distribution after you're gone. It doesn't help you while you're still alive. It doesn't avoid the probate process. It still has to go through and be approved by a court and a judge. And it's not binding. It can be changed. There is a better option that's available to all of us. It is called the revocable living trust. The living trust is a legal document that allows us to transfer our assets to our heirs when we die, but it does so without courts, without probate, without delay. And most of the time, if you do this right, without the family fighting. Because unlike a will that can be challenged and argued about, the instructions in your living trust when you die are binding. When you create a trust for your family, you are in essence saying, hey kids, here's what you get. Now, whether you like it or not, that's optional. But you are getting this asset or this percentage or this property. It is not subject to debate. When I die, the instructions are set. If you're unhappy, you can take it up with me in the afterlife. But I don't think we'll care when we get there. But the truth is, this is a binding set of instructions where the will can be challenged. The trust, folks, not only makes a smooth transition of our assets to our heirs without courts and without government intrusion, the living trust does take care of us while we're living, because in the living trust are these incapacity documents. I want you to think of a living trust as a portfolio of multiple documents. There is the distribution section, like who's going to get when I die and where it's going. But there's also these three important documents that deal with how I'm going to be dealt with or treated while I'm still alive, but maybe not capable of helping myself. So everybody, and by the way, if you are married, you will more than likely, not necessarily, but more than likely have one trust for the two of you. It's called a joint marital trust. But within that marital trust, you each get your own separate powers of attorney for financial and health care and all that. You don't have to agree with your spouse on you get to pick your own. So let me discuss those briefly. There is, with every person within the trust, and again, if it's a couple or an individual, there is a power of attorney over financial and legal matters. And that is, hey, if I can't pay my bills, I'm mentally not capable or physically, I have authorized someone with my checkbook to pay, make sure the lights are on, the heat's on in the winter. I am giving them the authority to do that. So they are my financial power of attorney. They are also, that same power of attorney is also legal power of attorney. So if a property needs to be sold and I need to downsize into something smaller, but I mentally can't do that, that person would also be able to sell property and buy another one. So they have legal authority and financial authority. It's called more or less the general power of attorney. There's another power of attorney that is included, and that is the healthcare or the medical power of attorney, sometimes called the healthcare proxy. And that is, who do you want to interact with the doctors? Consent to surgery. If you're unconscious, you cannot consent, so someone has to speak for you, and so you'll pick that person to act. And that is not about money or legal, but it's just about medical decisions. There's a third document that's part of these three, the incapacity, and this is the Advanced Medical Directive, sometimes called a living will. It's different than a living trust. But the living will or the Advanced Directive is basically, how would you like to be treated if you're on life support, feeding tube, respirator, if you're terminal? How do you want that played out? You get to put your 2 cents in now. When you think about the word Advanced Medical Directive, directive is like direction, here's what I want, but you got to do it in advance because you can't do it when you're in that situation. So in advance, if this happens, this is how I want that played out, So you're thinking forward, Some of you in this room, probably many of you, remember the name Terry Schiavo. It was a girl in Florida. She was in her late 20s. She had a terrible accident, and she was in what we call a vegetative state. She was not in a coma, but she was not very responsive. She couldn't feed herself. She had a feeding tube. After a while, her husband said, Terry would not want to live like this. We're going to disconnect the feeding tube and say goodbye. Well, her parents said, hey, hold on. No, you're not. When we come into the room, she sort of lights up. So what happens is they went to court. And as you know, in court, somebody wins and somebody loses. And the one that loses goes back to court and they appeal, and then they go back to court and they go. If you don't know the story, they were in court for 15 years, all about the feeding tube. Do you know who eventually decided her fate? The state of Florida. My point about that is simply this. It is not because Terry had no wishes. Terry might have been adamant. I would never want. It is because Terry had not expressed her wishes in writing in time. I'm going to say something that's really true, but it's also a little blunt. It is not going to matter what you want. It's going to matter what you wrote. Did you get your wishes in writing? This is really important stuff. Yes, this living trust is about distribution when you die, but it's also about some important things prior to death, how you'll be cared for. Will my wishes be honored, So this is really important. Now, I like to break words down. My goal is education and learning. My wife is a retired teacher, so we believe in, education. These documents are critical because, again, it matters where the assets end up, but it matters how we're cared for prior to that. And so breaking the words down, probate comes from the word probare, to test, to prove, to challenge something. The phrase power of attorney, the word power here means authority. I am empowering you with my checkbook to take care of me. It's not your money, it's still my money, but you're the one that can write the checks for me. You're empowering them, so power comes there. And the word attorney does not mean someone that went to law school. It means advocate. In a courtroom, your advocate is the lawyer, right? But in this scenario, it's going to be a family member, right? Who do you want to care for you, to make decisions for you? Now, I happen to have a choice that many of you in this room have, and that is I'm a married man, been married 39 years, going to be 40 pretty soon. My lovely wife, Christy, I have selected as my power of attorney for financial and health care. So she's my power of attorney and I'm hers. Does that make sense? We've selected each other. But what if my wife and I got into a bad car accident? In the car accident, I become impaired, but she dies. I now need a power of attorney, but the person I selected, unavailable. In this scenario, I not only lost my wife, but I just lost a power of attorney. So when you name your first choice, that is my primary choice. Always name alternate A and alternate B. Why? You have no guarantee that the person you want will be there. They could be in worse shape than you. So you have to think, okay, what if, and then what if, and then if not? You know, these are important parts of this thinking through scenarios that aren't pleasant, but important. I happen to have some pretty good choices for the alternates. I've got 4 adult children. I've got a daughter that could tell you how much money she has in every account and how much she's saving for Christmas. She's married to an accountant. She's good with money. So if I can't be there for Christy or she can't be there for me, that's the girl that goes to her. I have another daughter that's a nurse and wears scrubs and works in a hospital with doctors all day. So when it comes to the medical power of attorney, if I can't help Christy or she can't help me, it drops to her. Now, if a doctor were to say to my daughter, hey, I need you to sign here for your dad's surgery, you know what she'd say? Hold on. There are always risks with surgery. Let's discuss this. What is this hospital's percentage of success rate with this procedure? What is this doctor's percentage of success rate? Look, she knows to ask the next question. Why? That's her area of expertise. She's seen good doctors and she's seen doctors, right? So I don't just want someone that says, where do I sign that paper? I want someone that's going to be an advocate for me. And I think you need to think in that realm too. Now, you may not have a doctor or nurse in the family. Granted, I get that. But, you know, and people over the years have asked me, Daniel, I don't have a doctor or nurse, but I have 2 kids that I trust and I love them both and I like them equally. And I said, well, I get it. I'm not going to make the decision. You have to make the decision. But which of the 2 of them is good under pressure? Because sometimes that job is like the doctor says, we need to decide this in the next 20 minutes. And that's pressure, you know. Also someone that has some backbone, that when the other family's saying, you're not going to do that, are you? I want someone that says, I'm going to do exactly what Dad instructed me to do. He appointed me and he gave me instructions. I may not even agree with this, but I'm doing what my father's instructed. Are you following me? Someone with some, you know, that's what I'm looking for. And I'll just remind you too, if your son is really bad with his money, he'll probably be bad with your money. So you may want to think alternate. So you need to think, okay, if you're married, I have a first choice, right? All things being equal, but who would I want as an alternate? That's the stuff you have to think about. So this is important. It's thinking about what can happen, not just what's likely to happen, but what can happen. And this is all really important stuff. Now, a lot of people have heard that a trust avoids probate, and that's true. But not everybody knows what probate is. I mean, they've heard about it, but they can't maybe know they don't want it. But folks, probate is a judicial process where when someone dies, the state, through the courts, they have to verify and validate any wills or instructions that you've left to see if they're current, relevant, up to date. They have to settle family disputes. They have to pay the debts of the deceased. And when all of this is over, eventually assets get distributed. But that's at the end of the probate process. There are 2 major misunderstandings about probate, and here's the first one. Some people think, they're wrong, but they think that a will gets you out of probate. And the logic is, geez, well, I wrote everything that I want, and it's signed and notarized. And I say, yeah, I know, that's nice, but it still has to go to probate. There are many reasons why, but I'll just give you one right now. A will does not always represent the wishes of the deceased when they died. Now, we assume it represented your wishes when you wrote it. I want this to go here, and I want this person to distribute, right? But after someone writes a will, sometimes things change, people change their mind. I had a guy come to my meeting once. He said, Daniel, he said, I got a will. He said, I wrote it 15 years ago. He said, the will gives everything to my wife, Kathy. He said, now the only problem with that is I've been married to Susan for the last 7 years. He goes, Kathy was my wife 15 years ago. She's now my ex-wife. I said, and according to this piece of paper, the beneficiary of your entire estate. Do you know what the legal term for that is? Whoops. I had someone come to my meeting not long after. She goes, oh my God, you just reminded me my ex-spouse is still on some of my accounts. I was busy getting divorced. I forgot about that. So people, do have out-of-date wishes. And if you don't clean it up or update it, then somebody else does after you're gone. Maybe to your liking, maybe not, but you certainly not the best scenario. And the second misunderstanding about probate is that some people think they don't own enough. And they basically say, well, geez, I'm not rich. I have a house. I got a couple kids. I got a pretty simple scenario here. Well, you do not need to be wealthy to trigger a probate. It does take a dollar amount. There is a dollar amount, and it's different in different states. And basically, the state says if you own less than a certain amount when you die, your estate skips probate. But if you own more than this when you die, your estate triggers the probate mess. Well, here in the Commonwealth of Virginia, that dollar amount is $50,000. 50. So your homes are worth multiples of that. Even a little condo would be worth 6 times that. So it is incredibly low threshold. In Maryland, it's also 50,000. In the District of Columbia, it's 40,000. What can you get in Washington, D.C. for 40,000? Parking space, maybe, I don't know. It is incredibly low in most states. North Carolina is 20,000. Most of the cars on the freeway are worth that or more. So it's incredibly low. Now, over the years I've been doing this, and I've been doing this for 22 years, I've had people say, Daniel, that number doesn't sound right. I think I remember it used to be like 675,000. Then it went to like 1 million. I said, yeah, that is never what triggered probate. But that used to be, back in the 90s, what triggered federal estate tax, which is different than probate. Now, if you do not know what federal estate tax is, it's something like this. The government says you died with too much money, but don't worry, they're gonna help you out. And they just start taking your money. Now, once you hit the level where you get taxed, this is sometimes called a death tax, Once you hit that threshold, what's usually lost over that is about 40%. So the government's thinking, for working so hard, we really appreciate that. We're gonna give it to these guys. The reality is that number used to be 675,000 in 1999, then it went to 1 million in 2000, then it went up 1.5 million, and it went up and up and up. And in 2010, folks, that was the year to die. I'll tell you, that's the year it went away. There was no federal estate tax in 2010. That's when Steinbrenner gave the Yankees to the family. He died that year. It was a nice favor to them. The next year it came back at 3 million, and it's gone up since. Today it's 13 million. So I'm going to assume most of you are just under that 13 million. You don't have enough to trigger federal estate tax, but you do have enough to trigger probate. Are you with me here? 50,000 triggers probate, 13 million. That 13 million is not going to stay. That's expected to come down, maybe get down to 4 or 5, million. And that would be a nice problem to have, but it would be a problem if God blessed you with a lot of wealth. You don't want to give all that away. But I want to tell you just one quick tax advantage, that if you are a married couple and you make a joint marital trust, you get to double whatever the federal exemption is. So if it's today 13 would be 26, I don't have that problem. But if it drops to 2 million, I would get 4 million, because when my spouse is making this with me, we get to double it. So one can die, I get to carry her exemption with me, or she dies, she gets, either way. So, okay, so a will doesn't get you out of probate, and you certainly do not need to be wealthy to trigger one. What's so bad about it? Well, I have done this workshop all over the state of California, Arizona, Tennessee, Texas, all up and down the Atlantic, Pennsylvania. I've been a lot of states. It doesn't matter what state I'm in, nobody likes probate. Here are the 3 big probate problems, and they're universal. Probate typically takes a long time, it costs a lot of money, and it's all very public. Everything's public documents, public forum, public courtroom, public everything. So let's go over those one by one. How long does it take an estate to get through probate? Again, every family's different, every probate's somewhat different, but the national average is 1 to 2 years. Assets are tied up in probate. Longest probate I ever heard was a lady in Culpeper came up after the meeting. She goes, Daniel, I'm not exactly sure how long my mom's probate lasted. She said, after 10 years, I told the family I'm not coming back. I'm done with all of you. She said, you can do what you want with my share. And then she leaned over and said, I think by then the lawyers were getting most of it. Could you imagine 10 years in court fighting with your family? In the last year, I've heard 6 years, 4 years. Just before COVID, I was in DC. A lady came up and she goes, they say it's going to be over soon, but we've been 5 years in probate and nothing's been distributed. Everything's still tied up. So probate, but the 5 and 10 years, those are not common. They happen, but they're not common. But what is common is 1 to 2. That is still a long time. Assets are frozen, money can't be divided. The second problem is it's expensive to let your estate go through probate. There are the attorney's fees, court fees, filing fees, assessors, sometimes accountants get involved. And where does all that money come from? the estate, right? This is money you were going to give your children, your grandkids, or your church is now going to attorneys, courts, judges. The national average of what is lost when an estate goes through probate, the national average is 8 to 10% of the gross market value. In Virginia, it's a little lower, and this is in your notes, so you know the notes you got there. It's in Virginia, 6 to 8% is typical, not 8 to 10. But what does that mean? We're in the expensive part of Virginia, right? Let me throw out some numbers, and I'll be incredibly conservative. Let's say that you had a little condo, and it was worth $300,000. You know, I know that was years ago, but let's just say it was $300,000 on the market, $299. I didn't say 6 or 8% of your equity. I said 6 or 8% of the gross market value, the selling price of your house. So $300,000 for the property, and maybe you had another $100,000 in other things, investments and antiques, and so your total estate in this example is just $400,000. 8% of that is $32,000, folks. That's a lot of money your kids won't see, and that's if they don't fight. I'll tell you right now, if Susie hires a lawyer, because Jimmy hired a lawyer, and they go at it, I've heard a zillion stories about probate. I could do 3 hours on probate stories. We won't do that to you. But I had this one guy tell me this. He said, Daniel, I knew when we got to court my sister was going to lie. He said, I just didn't think she was going to lie that much. She kept going on and on. Your Honor, this isn't fair. Mom really wanted me to have that. And I know that's what the will says, but we were having a fight when she wrote the will. And it was story after story. He said, I finally had it up to here. He said, I blurted out, Mom would be spinning in her grave if she heard you. That's not true. He just said it. The judge hearing all this said, would you all please approach the bench? So, they came forward. And the judge said, listen, here's my recommendation, is that you all go in the hallway and work something out. Because he said, right now, you are giving your mom's money to these attorneys. And he said, if you haven't noticed, these attorneys are in no hurry to get out of here. The longer we spend arguing about where it should go, he says, let me tell you where it's going. It's going right there. So it can get adversarial. Now listen, when there is, a fight, and it does get adversarial, very often it's not your children that started the fight. It's the ones they married. It's the daughter-in-law who says to your son, how come she's getting out? Next thing you know, he's not talking to his sister, but the lawyers are. Think about the dynamics here, folks. It's money, and sometimes all of a sudden, and sometimes quite a bit. And it's money, and then it's family, and if that's not enough, let's throw in the in-laws, and then expectation. I thought I was going to get that. And then opportunity. And all of this is a perfect storm. Not a good one, but one that creates it. I've heard a zillion stories about probate, but most of them start with a simple line like this. I never thought my family would act like that. And then the story proceeds from there. You see sometimes a different side of people, which is sad. So probate is not only lengthy, it is expensive. Here's the third problem. It is very public. Did you know that when you die with just a will, your will becomes a public document and anybody can read your wishes? Nosy neighbors, ex-spouses, disgruntled family members. But not just read your will, anybody can also contest it. Not all wills are contested, I know, but usually when they are, it's family, Why is Jimmy getting the boat? Grandpa promised me the boat. Well, at the end, Grandpa promised everybody the boat, if you know what I mean. The wheels weren't spinning like they used to. Some of you in this room, many of you will not know, but some of you might remember the name Charles Kuralt. He was a CBS reporter. He had a show years ago, On the Road with Charles Kuralt, Sunday mornings. Well, he died about 22 years ago, and when he died, we discovered he was not alone on the road, apparently. The article says, woman lays claim to the Kuralt property. So here's what the article says. The article says that Charles died with just a will. As the will was going through probate, a woman showed up and said, Your Honor, Charles and I had a long-term affair. She called it relationship, but he was married, so we all know. She said, and I'm entitled to some of this. And she said, Your Honor, I can prove it. So out come the love letters and handwritten notes and receipts. We call that evidence. Today it would be text messages and emails, right? You could ask Tiger Woods or General Petraeus, I guess. So what did the court do? Well, they listened to her claims. They looked at the evidence she presented. And then it says the court then awarded her the ranch in Montana, all the buildings on it, and other property. When I read that, my first thought was, why would the court do that? She's not even mentioned in his will. But remember what I said earlier, your will is a set of instructions, but it is not binding, and wills do get changed. Well, folks, that's a lot of bad news. Could I get, I don't know, a napkin or something? These lights are not helping me at all. If anything, just a paper towel from the bathroom. I'm sorry to ask for that. I should have prepared. Anyways, thank you. We'll start with that. I'm sure it'll leave little white things on my forehead, but we'll go with that. Thank you. I'm just going to take it right here. Now I'm like a Southern Baptist preacher. Come on. Here we go. I feel it. I feel it. Okay, so where was I? It was something good, right? The good news is, here's the good news. You don't need to have a probate. It is an option if you want probate. Don't do anything or just have a will. But there is a way to get out of probate. When you get a revocable living trust, the first benefit, no probate waiting for the family. What does that mean? That means instead of your assets being tied up in the court system for a year or more, literally, folks, within days of your passing, assets are available for distribution. I mean, while people are in town for the funeral, assets can start to be distributed. Now, it probably will not surprise you to know this, but I happen to have a revocable living trust. So do my brothers, so do my sisters. When I die, the family will all go to the funeral. Section 2 says they have to attend. And then my son will grab the book and he will go to the bank. And he will say to the bank, look, my father has $30,000 with you guys. He died last week. Here is his death certificate. And he will show them that. And then he will say, and here's my father's trust. My father's trust says he's the trustee. I am Charles, the successor trustee. It's like an executor, original trustees, successor trustee, like an executor. The bank will say, okay, you prove that your father's dead. Can you prove that you're Charles? I mean, you could have found this in the parking lot. So he'll present his ID. The bank will turn to him and say, so Charles, what would you like to do with this $30,000? Now think of what I just said. I died last week. Monday's the funeral. And Tuesday he says, 4 checks, please. Here are the names. And he closes the account. He calls his sisters over and says, here's the money from Dad's Truist account. I have 2 more accounts I'll be getting later this week. While I have you here, who's going to help me get the house ready? I've got realtors coming on Monday. We're putting the house on the market. You know why? There's no probate. There's no delays. We can start this now. But what if I died without a trust and I died with just a last will and testament? Well, they all go to the funeral. Next day, Charles goes to the bank. He says, look, my dad has $30,000 with you guys, and he died last week. Here's his death certificate, and here's my father's will. His will very plainly says that I, Charles, am the executor. Can I have the money, please? And you know what the bank says? I'm sorry, Charles, but this account is now frozen until the will goes through probate. There's a simple reason why. There's multiple reasons, but I'm going to give you one right now. Every will you've ever written, if you've ever written a will, says last will and testament. Nobody listening to me this evening wrote first will, second will, third will. They all say last will. How does the bank know if they're looking at the last of the last wills? There might be another will out there that I don't like, so I'll bring the one that I like. They're not going to release the money because the will hasn't gone through the process. But with the trust, access right away. Instead of your family losing tens of thousands of your hard-earned dollars in the cost of going through the probate mess, whatever you spend on a trust is going to be a lot less than probate. Now, I am not going to shock you when I tell you this, but did you know that attorneys don't do this for free? You can go out and find an attorney and sit in a nice leather chair and tell them what you want and have a trust made. I'll just tell you what most people tell me. Daniel, we spent, and then I usually hear a number between $3,500 and $4,500, or sometimes more than that. But, that's typical, maybe $4,000. That's a lot of money, but compare that to 8% of the gross market value of your estate. We're talking, $50,000 or $4,000 or something like that. You should run the numbers, but it's going to be a lot worse than that. Now, my company charges a lot less than the typical. We're a lot less than 4, less than even 3. But the reality is, even if it was $4,000, it would still be a better investment to do this than to let it go through probate. I'm just letting you know, just simple math, this is a better option, okay? Because you do this, you eliminate the lawyers at the end. You just get a lawyer to do it now, and you eliminate lawyers at the end. This is a much better mathematical decision. And the last thing is the privacy. The privacy issue. Now, I mentioned your will becomes public. And you know when someone dies, something shows up in the paper about a week or so later. What's that called? Obituary. Sometimes death notice is also a term used. There's another thing that shows up in the paper a year or two later, and that is the announcement of probate. They have to tell everybody a probate's coming so people can come and so forth. I brought 3 or 4 examples here. It's the part of the local paper that you don't read because the print gets really small and there's no garage sales. You know, it's people have died and there's a probate. And some of the examples are simple, but the beginning of each of these, it has 3 headlines. And it says, notice to any creditors, notice to any unknown heirs, notice to all persons interested in the estate of, and then there's the name of the deceased. So who was just invited to probate? If you can Google, you can get interested. And then it tells you 3 other things, not just, hey, come one, come all. It says the name of the person that died, when they died, and if they had a will or not. Everyone on here, and I got 3 papers, all died with a will except one. This person died in 1998 without a will. And this is a 2020 paper, so 22 years later, they're still in court. Now, all of them are a year or 2 or 3. Some are, like that one, 22. I've got some here 6 years. So, but the reason I'm pointing that out isn't that probate takes a long time. No one's going to tell you probate was like this quick. It takes a while. But all of them but one had a will. So when your friend says to you, well, I got a will, there's no probate, right? They just haven't read the paper. The paper will tell you with a will, there's still the probate. So, but that's a lot of publicity, right? Anybody can show up in court. Anybody can find out what you had, who's receiving. All of that is very public. Let's contrast that with the trust. With the revocable living trust, the only one that gets to see the details of your trust when you die are your named beneficiaries. That's it. Not nieces, not nephews, not neighbors, not ex-spouses. The only people that get to see what you have left and who's getting it are the people named in it. And that's one of the many reasons why Susie Orman, Wall Street Journal, Forbes magazine, they're all telling you, you want a revocable living trust. Modern Maturity magazine wrote this. They said, if you look forward to going to the dentist or paying taxes, you might like probate. They said, probate is costly, slow, outmoded, a sad state of affairs. Trusts, however, are a valuable estate planning tool. Some of you might be familiar with Susie Orman, seen her on TV, read her books. She says, regardless of how much you do or do not have, in most cases, a will is not enough. You will also need a revocable living trust with an incapacity clause. What's that? The powers of attorney, the advance directives. Susie wrote that in 2004. Here's a more recent article she wrote. In trusts we trust. I love the play on words. Let me read you one line. She writes, wills are required to be approved by a probate judge. But with the revocable living trust, your estate is dispersed exactly as you laid out in the legal document. And then she writes, no need for the heirs to get court approval. With the trust, we're bypassing the court. They will just pick it up and do as instructed. Okay, we talked about the do-nothing plan. I do not recommend that. A will is certainly better than nothing, right? I mean, having something in writing is better than nothing, right? Because then they can just all make up stuff, Wills can still be contested. It still takes a long time and chews up a lot of money, but it's better than nothing. But by far, a trust is the best option for most families. There's another option I do not recommend, but I want to discuss it, and I want to talk about the dangers of joint tenancy. And then an audible gasp in the room. Most couples own assets together, right? Jointly. When one dies, who owns it? The other one. There's no probate when the first spouse dies. But eventually, the second spouse dies, and then there's probate. What happens if the couple that owns the asset together dies together? Car accident, COVID, something, instant probate. There's no one left on the title for it to fall, so it goes to the court. So just so we understand the basic rules here, joint tenancy doesn't solve your probate problem, it just postpones it until the second one goes. Are you following me so far? Some people think they've come up with a shortcut, and here's what they say. They go, well, now that my spouse is gone and I own the property by myself, or the accounts, I don't want it to go to probate when I die. I've got an idea. I'm going to put my son or daughter on title with me. That way when I die, they'll take over. Skips probate. Well, it does skip probate, but it opens up so many other problems. In many cases, it's worse than probate. Probate's bad, but there are things worse than probate. Let me give you the 3 reasons you do not want to own assets with your children as a way to pass the estate to them. Reason number 1, it's not a good idea, is liability. When you put a son or daughter on title of your home or bank account, they're not just joint tenants, but they are now co-owners. As a co-owner of your house or your accounts, if they were to get into a car accident, their dog bites somebody, someone slips on their property, there's a lawsuit, then a judgment, what could they attach? Anything they own, which is half of your property. Imagine this, you put your daughter on title a few years ago, she discovers her husband, your son-in-law, is cheating on her. She throws the bum out, they divorce, but in the divorce settlement, half of what she owns goes to the ex. I said 25% of your equity just left with your ex-son-in-law. Ouch. And you wanted to give him something else. My point is this, when you commingle assets with your children, their problems become your problems because they affect your estate. That's just reason number 1. I have 2 more. Reason number 2, it's not a great idea, distribution. Let's say the 4 of you up here are my 4 children. I make a deal with my son. Hey, mom's gone. I don't want the house to go to probate. Let's you and I own it together. When I die, I would like you to sell the house and share it with your sisters and your brother. And he says, okay, Dad, I'll do it. The question I have is, does he have to? No. He got a house and the 3 of you got disappointed. I'm going to tell you right now, I'm sorry to break the news, but brothers cheat sisters and sisters cheat brothers, and they somehow justify it. I guess Dad knew I needed that house. No, you didn't do it. You said you'd do. Let me make this really clear. I had a plan. It was just a lousy one. Deceased father cannot make him sell, and neither can his siblings. He got a house, and you did not. Let me ask you this. Getting 0 or going through probate, which would be worse? At least at the end of probate, you'd get something, right? But in this grand plan that Dad had, 3 of the kids got zip. So there are things worse than probate. That's just the second problem, distribution. But let's say you don't have multiple children, you have 1 heir, and you're giving everything to Barbara, your 1 daughter, let's say. So you put Barbara on title, and then you die. Now Barbara owns the house. But watch this. When Barbara goes to sell the house, she has to pay capital gains tax all the way back to your original purchase price. So imagine you bought your current house 20 years ago and paid this, and 20 years later it's worth this. That's called a capital gains. Let's just make the math easy for the speaker. 20 years, 200,000. I know that was just the last couple of years, but we'll just say it. 20 years, 200,000. Do you know what 20% of 200,000 is? $40,000 to the IRS in capital gains tax. But listen to this. None of that's going to happen when you pass it through a trust. When you pass your estate through a living trust, there is no capital gains tax due. None, 0. Because everything in your trust when you die will go to your heirs at the current value. It's called, if you want to know the CPA term, it's called a stepped up tax basis. The IRS doesn't care what you paid. What's the value when you died? That's the value it shifts to your family. No capital gains. But not just on your primary residence. If you've been blessed with a second property, a vacation home, a rental property, an investment property, as long as it's going through the trust, that also gets a stepped up tax basis. What about stock that you bought 30 years ago that paid, $20,000, you paid $20 a share and now it's trading for $120, well, this week. Anyways, the point being, that's also a capital gain, but if it passes through the trust, there's no capital gains tax. So that's one significant benefit. Distribution problems are gone too. If the trust says 25% for my 4 children and I die, what's the trust say? 25%. It's not negotiable. It's not contestable. Listen to the words here, folks. Revocable living trust means while I'm living, I can do what? Change it. I can revoke my previous instruction. But when I'm no longer living, it becomes irrevocable. It may as well be called revocable while living trust. While you're living, you can change it. When you die, it becomes irrevocable. So I often tell people, if you do not like what your parents wrote in the trust, when they die, you will have the right to be disappointed. And that's it. It can't be changed at that point. I would rather be the one deciding where it goes and how much goes than let them fight it out or come up with their own version of what's fair. It is our our assets that we get to bless them, we get to say so. And we get to say so with the trust. It's much more binding than the will. And the last thing is the liability. Just because I have a trust today does not mean my daughter cannot divorce her husband. She could. It doesn't mean my son couldn't drive too fast and lose control and injure somebody with his car. Those things could happen. But if those things happen today, those things will affect their estate, not my estate, because we did not commingle the assets together. So there might be another way to avoid probate, but it comes with so many downsides. With the trust, I'm saying, hey kids, here it is, come get it. No fighting, no courts, no taxes, no delays. It's just significantly better in so many ways. Okay, let's say with that knowledge, let's say you now think, I would prefer to get a trust. I think that's a better option. How do you get one? Let me give you a couple options. Obviously, you can find an attorney and have a trust made. And if you do, seek out a good attorney that does this for a living. I mean, my company does this, and we have lawyers in our network that do this, and we do this at a real reasonable fee. But the point is, if you're just going to find a lawyer, get someone that does this, not just someone, I can do that. No, you want someone that does this. This is a very... President of the American Bar Association said many years ago, he said, any attorney can write you a will. He said, they all learned that in law school. Your local real estate attorney could write you a will. He said, but less than 1% of attorneys have ever made a revocable living trust. So, and then he said, let alone a good one. So you want someone that does this for a living. I sometimes say, if I ever need heart surgery, I want you to know I'm not going to go to the ear, nose, and throat doctor because he's closer. I'm going to find a heart surgeon. And someone will, well, Daniel, they all went to medical school. I know, but I want the one that works on the heart. All lawyers go to law school, but you want a lawyer that's, understands this, that does this, that's experienced. So obviously you can find an attorney, but get one that knows what they're doing and don't just settle for, Obviously finding an attorney, it's, when I say it's expensive, it is more expensive than a will, but compare that to probate. This is a great value. Let's go to the other extreme where you don't use a lawyer at all and you run down to Staples and buy a kit, fill in the blank. Or you go to LegalZoom.com on the internet and create your own documents. The problem with the kits, folks, is there's no attorney guiding you, helping you, answering questions, double checking your work. Nope. It's you with your law degree creating a complex legal document that you hope works. And by the way, if it doesn't work, you won't be around to see how it turned out, right? This all takes place after you're gone. So, that's kind of dangerous. Now, I will not say anything bad about LegalZoom, but I will read you what LegalZoom says about themselves. These are their words, not mine. I know you weren't thinking about this, but you've got friends that might have thought about it. Here, if you go to any search engine and type in LegalZoom disclaimer, here's the page that comes up. I'll just highlight a few quick points. It says, LegalZoom is a document service and not a substitute for the advice of an attorney. It says, LegalZoom is not permitted to engage in the practice of law, so you will get no advice, explanation, opinion, or recommendation. If you're doing it wrong, they can't stop you. It says, LegalZoom, at no time will we review your answers to see that they're legally sufficient. But I love this one. LegalZoom cannot guarantee that the information on our website is current. Law could have changed a few years ago. So look, if you were going to get a patent that within a year that would go through, maybe. But this is a document that you're putting all your eggs in this basket. You want this well made. You want this very well made. So obviously you can find a lawyer. You can do a kit. We also do this. Let me just tell you some things how a good legal consultation should sound. And again, every attorney's different. But you want them to be thorough and detailed and ask questions that you didn't think about because they're the experts. They should know to ask the next question and the next question. So, sometimes the questions would be like, well, how are you? Let's start with distribution. First of all, tell me when you die, do you want everything to go to your children? Do you want it to go equally? Do you want to give some assets directly to grandchildren, sort of a grandparent gift? What about churches or charities or organizations? So those are questions that should be brought up. First of all, let's talk about distribution. Where? Attorney might say, do you want everything to go from your trust to your heirs as soon as you die? Or would you like to leave some assets in your trust for years after your death to fund your grandkids' education or maybe great-grandkids' college education? Look, you may not know this, but You can leave assets inside your trust if you want up to 70 years after you've passed away. I do not remember my great-grandfather, but if he left me money for college, I would remember him fondly. We have a dear friend of our family, graduated medical school about 7 years ago. He's in his mid-30s, he's now a doctor. And he graduated medical school with zero debt. Yeah, one of the few in his class. How did he do that? Well, his grandfather created a trust years ago, and his grandfather's trust says something like this, extreme paraphrase. Hey, grandkids, listen up. There's money over here, but there is no money for trips and motorcycles. It is for your education. And then he said, go to the best school you can get into. I am your scholarship. He said, I haven't talked to my grandfather in 15 years since he passed, but I thought about him every time my tuition got paid. You know why? Grandpa thought about me 30 years ago. And I'm talking about, again, that kind of education, like formal after. But I'll tell you today, especially here in Loudoun County, I would want to put a clause that says if my grandkids want to go to private Christian school and the parents don't have the resources, that I want my trust to be able to do, so we can think beyond just that, anyways. Just giving you ideas, that's the idea. You want an attorney that challenges you, brings up ideas, not just says, okay, how many kids, where do you want to go? I mean, you want someone that goes, okay, what about this? Have you thought about that? Some people do this, So a good attorney is also going to ask, things, they're going to talk about the realities of family. Now, the attorney might say, look, I see you've got a son and a daughter. You want them each to get 50%. No problem. But what would you want to have happen in the event you died with your son? Car accident, you're going to dinner. Would you want your son's share to go to his sister? Or would you want his share to go to his wife? Or would you want his share to be kept in the trust for his children, your grandchildren? And next question, when would you want it to go from the trust to your grandkids? When they turn 18? Well, you can do that, but they won't have any money at 19, right? How about 25 or 30? Someone the other day said, keep going. But if you just say where, I guess it would go to her children or his children, but you don't say when. You know when is? 18. You know what an 18-year-old does with inheritance? Woo, college, who needs that? $150,000. 2 years later, the money's gone and so's the scholarship. Why? Because someone didn't ask a simple 4-letter word, when would you like it to go? Now, we make a default for our clients. You can choose whatever you want over 18, but we typically think 25 is a little better than 18. Hopefully, they've learned some lessons between 18 and they've been on their own a little bit, hopefully, right? And so by then, they'll be a little wiser. I have some clients that say, I want them to get half at 25 and half at 30. Let them make their mistakes on some, not all. So again, we're giving you ideas, thinking through, I've had some people put a clause that says they must take a Dave Ramsey course and learn all about money before they get their inheritance. Well, they sign up for the next class that shows up, I'll tell you that. But then they're not thinking about crazy stuff as much, right? Hopefully. So, you get to write the rules of distribution with the trust. So, the attorneys are asking good questions. Now, the attorney, again, is also going to deal with reality, and the attorney might say something like this. Within families, there are people we love, and there are people we tolerate. And some people will tell the attorney, look, I do not like my son-in-law, don't like the way he treats my daughter. I want the money to go to her, but if she's not there, I want it to go to her children, but not her spouse. And the attorney will say, not a problem, we can exclude your son-in-law or daughter-in-law. But a good attorney says, I got another question, though. When you say you want your daughter to get her share, but if she's not there, it's to go to her children. When you say her children, did you mean biological children? Because what if later in life she remarries someone who has 3 kids from a previous marriage? Those are her children. They're called stepchildren. Well, stepchildren are children and foster children are children, but those are not biological. Are you following me? So, I had one lady say, well, I've never met my son's second wife's kids. Why would I consider them the same as the ones that come every Thanksgiving? And I said, apparently you don't. Maybe we better make sure this goes to the ones you want it to go. But if we don't ask that question, right? So this is detail. This is thinking about things that can, not just likely to happen, but can happen. It is not natural to think of the death of your kids. If I had anything to say, parents will die first, children next. But that's just not the real world. That's not the fallen world we're in. So we have to plan for what can happen, not just what's likely to happen. So very important. So, really, really important. Now, let's say, we talked about the LegalZoom. Let's say I did a kit, no lawyer involved. Here's the LegalZoom, plan that you get to make yourself. Remember, no lawyer. There's a blank spot that says special instructions. So I go, honey, listen to this. Why don't we leave $70,000 for the grandkids' education? That'll get them started, I die. My grandson discovers there's money in a trust for his education. You know what he says? Woohoo! I'm going to jet ski school in Florida this summer. Well, that's not what I meant, but it says education, and he wants to learn how to ride a jet ski. It's called See Do You. A good attorney would say, Daniel, when you say the word education, did you mean an accredited college, a university, a trade school, a law school, a medical school? And you know what I'd say? Yeah. He'll say, well, we better write that, because if we just say education, it could be Joe's fishing school. Precision language gets precision results. Vague language, vague results. Again, this is why we want lawyers to know what to ask so we can answer. You don't answer questions that are never given to you, right? So we want them to say, what about this or what about that? We could leave it like that, but that could open the door to this. Let's tighten that up. So this is the expertise. Now, when my trust was made 22 years ago, all of my kids were under the age of 18. So I have a section called guardianship somewhere in here. Guardianship, there it is. Who's going to raise those kids if we die while they're minors, Well, my youngest is 27, and they go up to 38, so they're all out of the house, they're all married. So it's irrelevant now, but it was very relevant for quite a few years. My sister, who's older than me, has a daughter, my niece, that is going to turn 50 this year and still needs a guardian. Special needs. She's about 8 years old up here. Over the last few decades, she's been getting what we call an SSI check. You know what that is? Government assistance because of her disability. If I were to leave an inheritance to my niece, hey, Deborah, here's some money from your Uncle Dan. Do you know what the state does? They take it. They go, thank you, Deborah. That's reimbursement for all the years you've been on government assistance. Or the state says, hey, now that you have this money from your uncle, Deborah, you don't qualify for SSI. And the check she's been getting for decades stop. Neither of those result, the government taking it or stopping, is a great result for my disabled niece. So what we will do for a client, without charging any extra, is create something called a special needs provision. And this is like a little trust inside the trust. When I die, the other assets will go to the other heirs right away. Homes are sold, money's divided to the others. But the money I left for my niece would stay there. And every month after I'm gone, she gets a little until it's gone. But that money, folks, over the next few years will supplement her checks. It will not jeopardize them. Isn't that better than losing the money? But how would you know unless someone said, you can't do it like that, but we can do it like this. This is why we're drawing the expertise of good lawyers. So the trust is made. Once the trust is created, it has to be signed and notarized, right? It's not in effect until it's signed and notarized. And the first thing you must do when you sign and notarize your trust is put some assets in the trust. So the first thing my wife and I did 22 years ago after we signed the trust is we signed what's called a transfer letter telling the county to change the deed. The deed of our home went from Daniel and Christy Leonhardt, the owners, to Daniel and Christy Leonhardt, the trustees. It's still our name, it's still our house, but we're not an owner now, we're a trustee. The trust technically owns our house. If the trust owns the house, who lives in the house? The trustees. Who pays the taxes? The trustee. Who pays the mortgage? The trust. Nothing changes but the title. I'm not an owner, I'm a trustee. Woo! Somebody move, maybe it'll come on. I don't know. These are the ones I want. Anyways, here we go. Good movement, see? So I also do that with certain accounts, money accounts, bank accounts, checking, they go into the trust. Now, even though the trust owns my house and owns my assets, I still write checks. I slide my card at Subway and they give me a sandwich. Where's the money come from? The trust. The trust is the housing that protects the asset. But let me say this, if you create a trust and sign it, but don't transfer any assets to the trust and keep the house in your name, then you own it. And if you own it and it's worth more than $50,000, it triggers probate. I had a client last night that came to my meeting, says, I have a trust, Daniel. I have 9 properties and none of them are in the trust. And I said, they are all going to probate if you die tonight. I mean, it wasn't that harsh, but if you don't get them in there. And the reality is, The state says if you own more than 50,000, triggers probate, but not if the trust owns it. Well, don't fear the trust owning it because it's still yours. You have access to it. The one way I try to describe a trust is sort of like a safe. If you buy a really nice safe and put valuables in the safe, are the things in the safe still yours? Yeah. Can you have access? Can you put something else in there? Yeah. The safe is just the housing to protect the valuables. The trust is just the housing to protect your valuables from probate and the in-laws that act like outlaws and all that stuff. So the trust is this mechanism to have assets, but not own assets so that it doesn't trigger probate. Are you following me? You know, nobody feels sorry for the Trumps or the Kennedys because they don't own anything. They got plenty of money from the trust to access. Don't fear this concept. Get it in a trust, enjoy it. You know, we have cars and houses and we travel, you know, from the assets in our trust. So it's just yours, but it's just over here now. That keeps it out of probate. So after the creating of the document, explaining the different where it goes, and then the document is created, then it's signed, notarized, and then the last part is transferring assets to the trust. Now, I'm going to cover a couple things real quick, and I know we got about 8 to 10 minutes, and then I have to excuse those with kids because of the nursery and all that. But when it comes to transferring assets to the trust, some things have to go in and some things cannot go in right now. So when we sit down with our clients, with every client, we create the transfer document to put the house in the trust, and then we take it to the county recorder and submit it. So we make it really easy on our client. Not like the guy last night that had all of those properties all in his name still. The problem is a lot of people go to an attorney, they sign the trust, and as they're leaving, he says, don't forget to fund it. And those are called your funding instructions. And you're like, fund it? Where do I go? Which county building? What about the house I own in Texas with my sister? Does that go in? What about stocks, mutual funds? And he goes, don't forget to fund it. And you're on your own. Then you ask your financial advisor, and he doesn't know that much. So we put our clients in front of someone that understands the money side so they can know what goes in. Because the one question when you're signing the trust isn't, how does this work and where's the money going? You already know that. That's been done. The number one question our clients have is what goes in there and what doesn't. You know, what about the assets I currently have? Do those go in? Don't they? How does that work? So obviously real estate needs to get in there. But many clients will say, well, I got a checking and savings. We'll go, yeah, here's the piece of paper you show the bank. They'll see that you have a trust dated on this date, and they'll make your accounts trust accounts. You're not getting new checks. Your current accounts become trust accounts. The bank just needs to know this is here. It's a paper thing. But then we'll get someone who says, well, I have an IRA or a 401k. Does that go in the trust? And we'll say, we cannot retitle your IRA into the trust today. If we do, the IRS could make you pay all the deferred taxes this year. So we will tell you to keep your IRA or 401k in your name, but everything, and government TSP or whatever, but everything that we will tell you to keep in your name has beneficiaries, meaning it's going somewhere, right? But for many of you, we will recommend that you change the beneficiary to the trust. Now, I'll give you a simple, an example. Okay. I'm the father. I've got 4 kids. You guys were my kids earlier. I'm going to find somebody else. You 4 are my 4 children. I'm the dad. My wife has already passed. I have a $400,000 life insurance policy. Now, we're going to tell you IRA should be spouses first. Any tax deferred thing, we call it qualified account. Spouses first, trust second, not children, trust. Now, here's the scenario. Dad, 4 kids. Mom's already gone. I have a $400,000 life insurance. You are named as beneficiaries. I should change it to the trust, but I didn't. And I took my daughter out to dinner, car crash, we both die. Where's the money go? To the remaining beneficiaries, third. And I just disinherited her children. Now think about this. They not only lost their mom, they lost their grandpa, and they just lost their inheritance to their uncles and aunt. But if I name the trust as the beneficiary, what happens? $400,000 goes to the trust. From the trust, it goes to my 4 heirs. But the trust says if she's not there, her share goes to her children, not to her siblings. So the trust already knows where I want. It has all that built in. But also because it goes to the trust, if her kids are under 18, they don't get the money till they're 25 because the trust says nobody inherits in lump sum until. This is just a better option. One more scenario. Don't worry, you all survive this time. Dad, 4 kids, $400,000 life insurance policy. I should change it to the trust, but I didn't. I left you on there. I died and you each got a check for $100,000. She enjoys the money, he enjoys the money, she enjoys the money, but you do not. And the reason your brother doesn't enjoy his $100,000, he's in the middle of bankruptcy. Anytime he gets any money, it has to go to the creditors. Not as much fun as the other 3. But watch this. If I name the trust as the beneficiary, what happens? $400,000 goes to the trust. The next day, the 3 of you will go to the bank and get your $100,000 and book your cruise or whatever. But your brother here's going to say this: I don't want my $100,000 right now. I'm going to leave it in Dad's trust, and I'll take it in a few years after bankruptcy with interest. He has the option because it's not his yet. It's going to him, but he can choose when to take it. He might also say this: I think I'm going to leave the money in Dad's trust until my divorce is final. Anybody want $100,000 showing up in your name in the middle of a divorce settlement? No. So my point is, this gives your children more options. If I don't know what my kids might be going through when I die, right? Well, we could all be raptured and this could be a lot less relevant. But the reality is, until then, we can't make our estate plan based on the rapture. We have to think about, okay, what if it's going to be longer? So it's important. Now, 5 more minutes. I got a few more things to give you here. I mentioned the trust can hold assets up to 70 years. And by the way, when I excuse people, I will also then start taking questions. I know you have questions. I have a grandson. I want to give him a gift. Let's say I want to give him $20,000. So I could write this in the trust. Hey, Wesley, I've set aside $20,000 in the trust for you. The week that I die, the successor trustee is going to write you a check. Have fun. Remember Grandpa. Drive careful. There's $20,000, no strings. But I could also write that like this. Hey, Wes, I've set aside $20,000 in the trust for you. Now, in order to get this $20,000, all you're going to have to do is show the successor trustee a diploma from a college or university with your name on it, or you turn 30, whichever comes first. Now what I've done is I've given my grandson 20,000 reasons not to quit his junior year. Now, if that's an incentive you want to do, it's called an incentive provision. I'm rewarding you for having got through those years and got your degree. Another incentive is one lady came to my meeting. She had a will only, $300,000, and it was all going through a will to one heir, her son. The problem is her 36-year-old son had been struggling with drugs his entire adult life, and her fear was after probate, he's going to have $275,000 to spend on drugs. Bad idea. So she puts the money in a trust and then writes this: Son, I assume after my death you're going to want some of this money. Here's how you can get it. The week that I die, and every 6 weeks after my death, you will be drug tested. The results will be given to the successor trustee. If those are good results, they will write you a check. If those are bad results, you will hear these words: come back in 6 more weeks with better results. She said, I did not accumulate this wealth to feed your drug dealing friends and your drug habit, and I won't. You know, as God has blessed us with resources, we are stewards, right? Good steward says, I want this money to go to my church or to a ministry or to missions before it goes to the local liquor store or to Charlestown or someplace else, right? If I know someone's got an addiction of some sort, I do not want to feed that. I don't think that's good stewardship. In my trust, it says, upon our death, this percentage goes to church. The rest of you guys can split the 90%. The reality is, my children know that we gave while we were living, and when we die, we gave again. God's kingdom can use the resources. I don't need it anymore. Let them be blessed with that. But you have a great vehicle to do that, having the right thing. Real quickly, some of the things that we do that beyond this, we give everybody the hard copy. We give everybody a digital version. We also create this really cool scenario. This is not my personal trust. Mine's at home. It looks like this. Imagine this. I have a terrible heart attack. I'm taken to an emergency room unconscious. The children show up and say, how's Dad doing? Doctor goes, well, he's stable, but he's unconscious. We need to do surgery. Which of the 2 of you kids has the power of attorney for health care? You know, I need them to sign off on the surgery. My daughter goes, I think that's me. You know what the doctor says? I think that's not good enough. I need to see the paperwork. So the kids have to go to the house and try to find it. Where does Dad keep this stuff? It's as messy as when I lived here. Oh, great, there's a safe. Do you know the combination to Dad's safe? I don't know. I play that out to say, what if you took the time to create this, but when you need it, there's a glitch. That'll never happen to me or our clients, because for our clients, we create a card for you, and if you're married, you each get one, and it says emergency access to my medical directives. This will be in your wallet. The doctors will not only know your name, they'll know the name of your primary healthcare power of attorney, the alternate. They will also know that you're allergic to penicillin or sulfa medication. It will also tell them that you have a medical condition like diabetes or asthma. It will give them the name of your primary physician and phone number so they can consult, and it will give them the HIPAA authority. But before they roll you into the OR, isn't this pleasant talk? The nurses at the nurses station will see the card. They will go to this website, punch in your member code, and right on the computer at the hospital, they will see your powers of attorney and your advance directives signed and notarized. And no one needs to go home and get them because they were in your wallet the whole time. Now, you will not get this when you just go to a lawyer, but you will get this when you work with a company that just does estate planning. This is our entire focus. After many years of making great documents, we discovered that no one was taking the trust with them on vacation. And you don't need to. Just take the card. Okay, it's 8:15. Those with children, I am obligated to tell you, the nursery probably wants you to go get them. But for the rest of you, I am here to take some questions. So, yeah, hands. Oh, wow, all the way in the back. Let's start there, and I'll work my way forward. Go ahead. You, then her, then we'll go. Go ahead.
What if you have to change it, and can you change it with maybe just minor changes, and can you change it with a different attorney?
Great. Oh, sure. Yeah, great question. Most attorneys don't like to work on other attorneys' work. Usually you would probably either go back to the original attorney or create a new one. One option. We have some sections that are pretty simple, like who's going to get the hutch and the piano and the grandfather clock. So this section, you would be saying things like, okay, grandpa's shotgun goes to my son John, and mom's wedding ring goes to Bob, right? You're itemizing things. And if you're going to change something there, you can use a pen. Like the kids all know that we're making a change, and that doesn't need to be notarized and changed. But if you're going to change anything else substantive, like changing executors or changing percentages, you need to have that redone, well written, because you don't want them to go, well, it says this. Well, I know it's scratched off, and now it says John. That just means a lot of confusion for the family. And then they're questioning, well, did John write that, or did Dad write that? If you're going to make any substantive changes, you want it done well with an attorney. And we give our clients a year of free changes after it's signed and notarized, and then we offer them an option. We have a legal plan where for $125 a year, they can stay in this legal plan, have access to 15,000 lawyers, but they can also continue to make changes. Not all, you're not required to do it, just an option to, but yeah, changes can be made after it's done. That lady in the back, because I kind of saw you, then I'm going to work my way over here. So let's go there. Yes. Yeah, with a mortgage or without a mortgage, doesn't matter. You're still the one on the hook to pay your mortgage. If it goes into a trust, they can still foreclose. You still have to. You still have an agreement with them based on your FICO score and your history and your income, and that's what they agreed when they gave you a loan. That agreement's still there. If you put it in a trust and you stop making payments, they can foreclose. So it doesn't change. They can't. By the way, by law, they cannot stop you from putting your house in, even if you have a mortgage. They cannot stop you. Yes, sir.
Would you review your recommendation on the IRA again?
Yeah, any tax-deferred account, IRS, 401k, government pensions like a TSP, those, the taxes you have yet to be paid. Those you're going to make the trust the beneficiary, but not the owner. If you're married, it's spouse first always so that she or he can take advantage of the benefit, but the trust should be the contingent. That's the way that would work. Other accounts, even life insurance could go straight to the trust because my wife is a co-trustee. If it goes there, what's she going to do with the money? Enjoy it from the trust. So it could go there, but other things like that, tax-deferred accounts, spouse first, trust second. If you're not married, but beneficiary, not ownership. No, not at all. All right, back here, I'm going to work my way across. I know I'm not going to be very fair, but I'll do my best.
Do you cover West Virginia?
Not at this point, I'm sorry. But you learned about it, though. Yeah. Yes, sir.
Similar to your point about the special needs provisions about a trust.
Yeah.
How would an NFA firearms trust be handled?
I'm sorry. Said interfaith?
No, an NFA
Oh, yeah, we can do those as well. A firearms trust is just a special trust based on government regulations and stuff like that. We can do that too. No, it'd be a separate document. Yes?
What happened when you have properties abroad, other country than US? Can you put it in the trust?
Overseas property, is that what you said? The trust made in America can cover US assets. I can say, you know, my chalet in the Philippines on the beach can go to my daughter, but I can't override the rules in the Philippines or Mexico or whatever. But you can make a trust in other countries, not all of them, but other countries you can do something like this as well. But I can only protect US assets with my US trust. But you can make the distinction of who gets, but it will not change the rules in that country. You'll need to address that. Whew. Let's do a couple of you here, and then I see you in the back. So let's go with you, and then the lady behind you. So, yeah.
So where are you located?
Ashburn. We have an office in Ashburn. We do this all over. Since you asked the question about West Virginia, or you did, we can do trusts for Maryland, D.C., Virginia, and North Carolina, and Pennsylvania. That's where we are currently providing for clients. Our Ashburn is where our office.
Those for you, you would assign us an attorney.
Yes, we have attorneys.
Meet qualifications, of course.
Of course, yeah, they're very good attorneys. We actually have a rule that says after you're done talking to the attorney, if you're not happy, we give you all your money back. You have to like the attorney, or you get your money back. You know, we're that confident that you will. After you get through the process to talk to the lawyer, you will like them, or you'll get your money back, and everybody's very happy.